Rolling.
All right. Welcome to the Consultation. My name's Josh Floyd. I'm an attorney here in Texas. We have a not so special guest with us today, Christina Jimenez, and we have a very special guest with us, John Teakell. Christina is a lawyer here also at the firm. John's not, and so John is going to tell you now kind of who he is, what he does, and why he wanted to join us for some reason.
Thank you for those words. Yes, I'm John Teakell. I do federal criminal defense, some state criminal defense. I was a state prosecutor as a young attorney, federal prosecutor for a lot of years. Been doing private practice for about 20, and I have federal cases a lot of places and state cases throughout Texas.
Awesome. Thank you so much for joining us.
Thank you for having me.
I love having guest attorneys.
The last one blew us away, right? She made us look really bad. Yeah. Could you try to make us look good? And this is our podcast.
I was very happy when Chandler said that you had reached out and you wanted to jump on and kind of talk to, everybody who listens to our podcast about criminal defense within the context of family law. And so prior to us getting on, I did tell you that we also do some criminal defense, but our practice really has shifted more to family law. I'm board certified in family law. Floyd's going to be board certified in family law this year.
Hopefully.
Right. And so that's kind of where our practice has shifted. But because family law and criminal defense sometimes are so or can be tied together, we have to know some things about it to protect our clients, right?
Certainly.
Yeah, but it's kind of like when we're dealing with immigration issues, criminal issues, tax issues, we're going and we're finding people like you who are extremely well versed and have made criminal defense kind of their specialty area. And so, I'm glad to talk to you about all this stuff. And so, kind of what I wanted to visit with you about today is admissions. Like if somebody has been accused of a criminal offense, what should they say? What should they not say? Like how do we proceed, right? I was explaining to you guys that I have had several cases, but I had a case where there was an alleged victim that came in. The wife came in and basically said that the husband had pointed a knife at her and, had threatened her verbally. No other witnesses, no marks, no bruises, nothing. And so then from the family law side of it, she files for a protective order. She files for sole managing conservatorship of the children. And I have to go to a temporary hearing and obviously prep my client for that hearing. And it wasn't fun because what would you tell me that I should tell my client to do?
Well, it's like you're indicating, generally in any situation, if you have a criminal investigation, or certainly if you're under indictment, being formally charged, and you have an administrative hearing or a civil matter that's pending, or for any other reason, generally, I think we'd all agree that you do not want your client making a statement because that could come back to be used against you in the criminal case, whether you're actually formally charged or you're under investigation. Now, I believe there's still case law that says that even if you're not charged or even if there's not a formal investigation that's opened, if it's a situation where that could happen, then you still have a good right to invoke the Fifth Amendment privilege against self-incrimination and not answer the question. So, given that, when you have situations where you have a family law proceeding and you have a court setting that's geared toward this, or you have statements, depositions, whatever that are to be taken, then it becomes what I call sometimes a gut check call. Do you want the client to go forward and answer that question? Do you just assert the Fifth Amendment privilege? Because that could in itself trigger a criminal investigation or a criminal case.
That's true. You know what? I've never actually thought about it from that context that it could trigger it. I typically just think if there's any question that they ask that it could potentially be deemed a criminal offense, I will typically tell my client, or jump up, judge, I would advise my client. And so, and even if I don't know if they did it or they potentially did it or not, I just don't want them answering that question because it scares the
Right.
crap out of me.
Well, remember we had that one case, it was a SAPSR case, but based on the dates of birth of the parents and the child, the judge found out that our client had sex with the mom when she was underage, and he referred himself to the DA's office. The AG had filed the child support case because the child was on Medicaid. Go to court, and judge is like, no, this was a crime. I'm referring to this DA's office.
Yeah, yeah. And so, typically the other time that we see these issues that I feel like a lot of family law attorneys miss is during CPS investigations, right? And so, in this particular case, children were present, and our client gets a call from Department of Family and Protective Services saying, hey, we want to come in and we want to visit with you about this allegation, right? And thank the Lord, he had already hired us on the divorce, and so we're kind of in the mix of all of this. But I see that happen so often, where people just sit down and they talk to an investigator for the department. And so,
Sure.
how does that affect you, in a criminal case?
Well, that's where it gets really dicey. It gets difficult when you have a CPS type investigation, because the consequences, or at least the immediate consequences, could be there and may work against the parents if they refuse to answer questions. So that puts them in a real tight spot, puts them in a bad spot, because if they say, well, we're not going to answer because of this, the investigator, the CPS people are going to presume that, oh, well, he did this and there's bad stuff going on, so we're going to recommend, children be taken out of the home, etc. So that is a reality where the rubber hits the road, so to speak. You have to decide what you're going to do. Best thing I could recommend is try to have your attorney limit that as much as possible, or answer some of those questions for the CPS people without your client making any or too many direct statements.
Yeah, so I just had this happen, and frankly, we have it happen all the time where, client calls me, they say, hey, CPS went to the school, spoke to my kiddo, and, basically, kiddo got out of line, and, I spanked him, and when I spanked him, it left a pretty bad bruise on their leg. And so now I have a CPS investigator coming to my house to talk to me, and I'm like, no, you don't. What is their phone number? I will be calling them right now. And like you said, I will go in and I will, not necessarily say that this is what happened, but I will always tell them, listen, our MO at our office is our clients just don't, especially if there's any criminal.
Modus operandi.
Thank you.
Mode of operation.
So, that if there's any sort of potential criminal consequence, our clients just don't talk to you guys, right? But here's what I can tell you, the little that I know, and
Right.
kind of try to soften what's happened,
Yes.
right? Like, okay, here's what's going on. You're more than welcome to talk to my client about, family history, drug history, mental health history, because that's like their basic questions. But you will not ask them about this particular case, right? I think I know that has probably saved a ton of our clients from criminal investigation, but or potential indictment, or at least we don't make it easy for the DA's office, right?
Right.
But I don't think that is something that a lot of family law attorneys know, right? I mean, they're thinking strictly from the context of, we don't want to lose the kids, right?
Certainly.
They're not thinking from the perspective of, I don't want my client to go to jail,
Right.
right? And so that's kind of where, you guys step in and say, hold on, don't say anything. But typically by the time you're hired, it might be a little too late, right?
Maybe later than you want,
Right.
but you make a good point about how a lot of attorneys, people who work at law firms, whomever, don't even think in that context. To me, that applies, I think, with a lot of civil practitioners, whether it's an insurance issue, talking to an insurance adjuster, insurance investigator, anything along those lines. If it's an allegation about money, taking money, misusing money, anything like that should trigger an attorney to say at least, hey, look, there could be other consequences besides what we can do to settle this or put you in a good position for our litigation or coming litigation, i.e. maybe a criminal investigation.
Right.
Without wanting to create an issue that doesn't exist, still, I think legitimately, as you've pointed out in the family law situations, those could apply across the board.
Right.
And so what I've found is that generally criminal cases are bad for family cases, but family cases can be very beneficial to criminal cases.
Right.
Right? Because if you have, we've done it numerous times, right? I don't know if you remember, but a few years ago we had a guy that was charged with ag assault. And fortunately, the DA filed the PO against, protective order against him. And so I was able to get discovery, all of her phone records, her text messages, through the protective order that I could then use in the criminal case, right? But with the criminal case pending, I can't have him testify in the protective order case, so the protective order probably gets granted, right? And the adverse impacts, this wasn't a child custody case, but if it was, right, the presumptions of supervised visits and sole managing and all the stuff that goes along with the family violence side of it. So the criminal case sucks because we can't testify in the family stuff, but you can use the family to your advantage to fight the criminal case through discovery. And we had one, we did depositions, and we got with the criminal attorneys like, what do you want me to ask? What do you need to know for trial?
Right.
And you can't get all that stuff in criminal
Right.
cases.
Well, that's a good point because
That's the only kind of points I'll make. You'll find that.
You don't know him yet.
being one of your good points, that is a good point. As you know, I would always recommend, sort of as a side note, but following up on what you said, to try to get in when you can, as early as you can in a criminal investigation, to try to, if you have something to work with, show the prosecutor's office, hey, look, you're not aware of this, you're not aware of that, or you may be operating under some incorrect or just plain bad information. So if you have that, then yeah, that would be a plus.
Yeah, because like in this case, we had her written statement she made to the police department. We had the sworn statement she attached to the affidavit protective order. We had her testimony in trial and her answers sworn to the interrogatories. All of them differed. And you go to the DA and you're like, look, she said this here, this here, this here, this here.
Right.
Right? What are you going to do in trial? Right? What's she going to testify to in trial? She's
Right.
changing her story.
Right.
It embellishes every time. So,
Well, and most of the time in the context of a criminal case, whenever the charges haven't been formally filed, right, that no indictment, no complaint, most of the time we can only get the PC affidavit, right?
well, you can get videos too, but it's a little more difficult. Sometimes they send up to the AG.
But what we'll typically do in the context of a family case when we're running a criminal case, concurrently, is when it's set for a temporary hearing, we'll subpoena all of those records and have the PD or the sheriff's officer or whatever bring them to us, right? And so we do, going to what you're saying, we get a jump start kind of on the criminal component to say, hey, here's all this other stuff that we have, and then we're able to then at a temporary hearing start questioning the alleged victim, kind of locking down that testimony, and start finding those holes in their case.
Yeah, that would be a real good tool to use to try to get ahead of the game as far as what you have and when you typically would receive it from the prosecutor's office.
Right. Because a lot of times, in the context of a criminal trial, the DA is going to sit down with the alleged victim and they're going to prep them and prep them and prep them, right? And so...
Not coached then.
No, they're going to
Just
prep them, right?
yes.
And so the DA, when that witness is, prepared for their testimony...
Very well prepared
Right.
for their testimony.
Then what's going to happen is it's going to be more difficult for you guys in trial to be able to find those holes, right? But if we get a hold of them in the context of this family law case, when they're probably not even talking to the DA at that point, right? All they've done is filed their police report and maybe talk to their family law attorney who maybe doesn't know anything about criminal defense. We can start figuring out, okay, here's
Right.
how we're going to win the criminal case. And like Floyd said, in that case, he did it because we were able to start using the civil component to help in the criminal
Yeah, that is a
side.
great tool for you.
Yeah.
It was a blessing. When they filed the protective order, I'm like, yes, thank you.
Yep.
Now I can get what I need.
Yeah, absolutely. I'm trying to think of other family law cases. So we have it in CPS investigations. We have it at our temporary hearing. So, going back to how it hurts us most of the time in the context of family law cases. So we go in, we have a temporary orders hearing. Going back to my example, wife's claiming husband pulled this knife on me and I'm scared for my life. I need my protective order. I need sole managing. I need, I need him to have supervised visits. We're literally put in a situation of choosing something bad against something worse, right? I mean,
Rock in a hard place.
Rock in a hard place.
Damned if you do, damned if you don't.
Damned if you do, damned if you don't type situation. Because it's very crappy for me to have to explain to my client, like, listen, you might get supervised visitation with your children, right? She might get sole managing. She might get the protective order. She's probably going to get the house. You're probably going to pay spousal support. Like, all of this really bad stuff is about to happen to you. But if you testify about this, then it's probably going to get worse than all of this other stuff, right? As a criminal defense attorney, what do you typically tell clients when they're asked questions and having to potentially testify?
Well, most of the time I'm not dealing specifically with family law issues and the intricacies of them like you all are. But again, generally I try to tell people not to make any statements, or if anybody contacts them, refer them to me, and then we won't make statements. It does become, like I said a while ago, a gut check. If you have some administrative hearing, as you pointed out, that could work against you, if you hold back and don't say, look, here's what happened, or here's my testimony, or, I can't make a statement now, then it could have some shorter term or maybe even longer term consequences. But again, if it's a situation where you are concerned that could work against them in a criminal investigation, you have to advise them whether they take the advice or not to, this can be used against you, and I really wish you would not do this. Now, there's been a couple of times or more probably over the years when talking about this with a client, it's like, don't think this is probably going to go criminal, but it could. It's not a for sure thing. Like, sometimes you can tell, oh, this is going to be a for sure criminal investigation if it's not already happening now. But it is the gut check. You look and see how egregious this is. Could it work against you? Still try to operate from the standpoint of, don't make a statement if you don't have to, but if it becomes crucial, then you really have to decide, is it worth it? Is it not?
So, okay, what would you tell people that say they got arrested for family violence, wife files for divorce, they've got some kids, right? When they're looking for an attorney, should they look for a criminal attorney, a family attorney, both? Which one first? How would you advise them to handle that?
I'm going to go family attorney. I'm just kidding. Go.
Well, I think that's the conventional thinking. I got to get a divorce attorney, a family law attorney, and I would say so. Now, within those scenarios, and you have what we're talking about, potential criminal cases coming up, or one that may be in the works. Are you going to add to it or not? So I just would hope that attorneys would be cognizant of that before they have clients go in and say, okay, I didn't do this, but I did that. Sometimes you can envision those things happening. Well, it's not as bad, but here's what happened. So you have to kind of weigh it out and see, do you think it's going to go criminal or not? You don't want to just guess, but sometimes you may be put in a situation with a client where you have to go, yeah, this is really important to you right now. I think it's probably not going to go there, but I can't guarantee it. So, again, that's probably one of those law school questions. What's the answer? Where you can write on for pages and pages.
Right.
There's no yes or no.
Right.
So.
Yeah. So, I guess the issue is not everybody I'd say probably most firms, right? They don't do criminal and family, right? You have attorneys that come out that are practicing family law. And so they may not recognize these intersections with criminal and the advantages that it can have and also the consequences, right? And so how would you advise a person when they're hiring a family law attorney? Like, what should you be looking for? You know, if they don't know anything about family, should they also hire a criminal defense attorney? Like, how can you protect them or they protect themselves from running into what you don't know what you don't know, right? And these family law attorneys are focusing on family.
Right.
So,
Well, what comes to my mind and what I think I've done in the past is saying, great, get a good family law attorney. Sounds like you're going to need it, but have them contact me and so we can talk, or at minimum, when you have situations come up about making statements, having a hearing, please have your attorney call me so we can discuss it before you go do that, whether it's written, verbal, or whatever. Also, as somewhat of a side note, what's coming to my mind too is, as you kind of alluded to a while ago, where you have sometimes one parent will make an allegation against the other if it's a divorce or a custody situation, whether it's he pulled a gun on me or he hurt my child or our child, whatever. You know, more and more, as I think we'd indicated earlier, we were talking on before we got started, from my perspective as a criminal defense practitioner, you see the cyber stalking that's being charged more and more, whereas years ago it might have been, well, threatening communications. He wrote me a letter threatening me or put a writing somehow threatening me. You're seeing the cyber stalking statute that's more recent, that not only if you place someone in danger or threaten to kill them, but just harass them. Email after email, letter after letter. That can turn into potentially a cyber stalking investigation.
so that's more than just a harassment charge. It can be a cyber stalk. How does that
It
work?
has to be more than just a harassment, but the statute reads something like, it places them in fear or has the potential to place them in fear or words to that effect. So what you see from that in a practical matter are the ones I've seen that are charged like that, where you have many, many just continued emails, just picking, plugging, stating, you can't do this, you're not going to do this, or I'm going to do this. So if you have a client who's already made some statements or sending out a bunch of emails, venting their frustration, probably ought to talk to them about ceasing that.
Text
Yeah.
messages too, just emails?
Could be text, yeah, text, any sort of media.
That's scary.
Yeah.
Because in our area of law,
Shit.
I mean,
Clients calling, we gotta talk.
Yeah. So we have a list now of all of our clients, because they, when people are going through a divorce, when they're losing their children, they're hyper emotional, not thinking logically, hardly ever, and so we have those situations
Right.
where, and a lot of times they're not threatening, right? But they're just like, I love you, I miss you, please don't do this. But it's over and over and over,
Yeah.
nonstop.
Yeah, I think that unless there's a specific threat, if it's sort of like you're talking about, 3 or 4 of those are probably not going to
No,
get you
I'm
to any
talking about-
any federal investigation. But
30 or 40?
30, 40, 80
We have
may
those.
well could.
Yeah, we have those, and I've never even thought about. And
Great
a lot
example
of
of
times,
we don't know, right? Now we know
Right.
about cyber stalking.
Right. Yeah, and I mean, we have that where our clients are the recipients of those types of messages, and so yeah, I mean that's concerning. So thank you for sharing that with us.
Sure.
What about the stalking protective orders? Because isn't that now like a thing, a harassment protective order, stalking protective order?
Stalking.
Do you know anything on those? No.
Not too much.
Okay.
Not too
Do you
much.
Do you remember? I have to look that stuff up all the time.
So there's a protective order under the family code, there's a protective order under the code of criminal procedure,
Mhm.
right? And there's one of the code of criminal procedure is stalking. You just have to meet the elements for stalking. I don't remember what they are off the top of my head, but it doesn't require a finding of family violence like the one in the family code does. And I think it could be for more than 2 years. I don't remember, but yeah, there's 2 different ways to go about a protective order.
Yeah, that's crazy. That's
So,
scary.
something else that comes up a lot, and you may know this, and I should probably know this for my test next time, but recording phone calls, right? There's always recording going on, video recording kids and the other parent, and recording phone calls and recording FaceTimes between the child and the other parent. Sometimes in the state of Texas, sometimes we have clients or opposing parties that live outside the state. And can you talk a little bit about how that works and what we're allowed to do and not do so we don't go to jail for any of this?
Well, my recollection is that every state you can do that except for two. I'm thinking Maryland and California. I'm not 100% correct on that, but I was thinking those are the two that did not allow one person who decides, I want to record this, to go ahead and record it.
Okay.
So,
So if I'm on the phone talking to my child, my wife and I are going through a divorce. Not going to happen, babe. I can't afford it. But if we were going through a divorce and I'm talking to my child on FaceTime, she's with him and over his shoulder recording what we're talking about. Is she a part of the conversation? Can she do that?
again, if it's supposed to be, as I recall, a party to the conversation, if one party decides they want to record it, basically they can do it.
Okay. In that scenario, though, if she's not a part of the conversation, if she's just standing there watching me and my son talk on FaceTime.
If somebody else, a third party, comes in and records it, and the party to the conversation is not aware of that, I don't think that they should be, or I don't think they're allowed to do that.
Mm-hmm.
Technically, I'd have to stop and think. There may be some statutes, state, maybe federal, but I think especially state, that would prohibit them criminally from doing that as well.
So it would be criminal, not just like a
I-
invasion of privacy.
I
tort
believe
type
so.
thing.
If they wanted to, if somebody wanted to make a criminal issue.
No, I mean, we've had that happen before where, the other parent is recording the calls between the child and our client. And then, we get discovery responses and they have all of these recordings and it's like, this is not going to be good for your client.
Yeah.
You probably should not
You
have done
said
that.
this, and then I wish you wouldn't have.
Right, yeah. So don't do that. I mean, and that's kind of what we tell all of our clients is if you are not the one talking on that call, you don't record it, right? And if you want to record it for whatever reason, you need to figure out a way to interject into that conversation so you somehow become a party to the conversation, and then it may be appropriate.
Right.
Yeah.
So do you deal with a lot of that invasion of privacy stuff, like cameras in somebody else's house, or getting into somebody else's phone?
Occasionally, but it seems like some of those that I've seen more than not would go to the state for a state prosecution. Some recordings, inappropriate recordings, or something like that, inappropriate camera shots, things like that. You have also, on the other side, a bit of a variation. In federal court, you've seen more over the last several years of computer intrusions, or exceeding your authorization to get into a computer network. So whether you get in to try to destroy it or harm someone or gather some sensitive information, that's what that's for. Might apply in your situation sometime, but not quite what you're talking about.
Wait, so going back to that, so sometimes in the context of family law cases, we have, where one client will go in and hack into the Facebook account, right? Or the, Tinder account, or
You say hack, they just get the password, right? They don't actually hack.
Well, I mean, they get the password not from the actual user, right. So they get into these platforms without authorization by some means, right? Is that what you're talking about? Is that what you're saying in criminal law offense?
Most of the time I've seen situations where somebody actually gets into a computer network,
Okay.
like for a company,
Okay.
or a law firm, or just someone's small business, what have you.
Mm-hmm.
That's a good question, because I think that might apply given the reading of the statute, and
Mm-hmm.
I'd have to see what the latest as far as the case law goes on that.
So earlier you had brought up destroying evidence, right? Now none of our clients do this, okay? But I've heard that there are some, social media accounts that have been deleted, text messages, email, stuff like that's been deleted. Are there potential criminal consequences associated with that?
Yes, I mean, the thing that comes to my mind is obstruction of justice. There could be state court, federal court, especially state court, if it's a violation of some sort of discovery order or protective order, then you have that, which could have civil or possibly criminal consequences. But yeah, there could be an obstruction of justice type charge that could come at somebody from doing that.
Yeah, so more people should do what our clients do and just not destroy anything.
Right. Yes,
Okay.
absolutely.
It's a safer way to go.
Yeah, absolutely. So going back to the whole, family law case and running it with, family violence case, running it with a criminal defense case. I mean, in the example that I keep going back to, I think the probability is very likely that on the criminal component or criminal side of it, he might be successful, right? He might be acquitted of the allegation if there was a jury trial. Because the burden for a protective order and a criminal offense is completely different, right? And so talk to us about the burden for a criminal case.
Well, burden for any criminal case to be proven at trial is beyond a reasonable doubt. Of course, as you know, it's the highest burden in the judicial system.
Can you give us a definition of that?
Yeah, I'd like to. I think I'll quote all the judges and all the holdings that say, well, it's just beyond a reasonable doubt. And then, of course, as you know, at the bottom is basically probable cause, which ain't much. Just like, well, there's seems to be a reason for this happening, so okay, yeah, we're gonna go in. So, and then you're clear and convincing, and your preponderance in between. So, beyond a reasonable doubt, the standard for a criminal, which doesn't apply really anywhere else.
Mm-hmm. And so,
but I think your point is that in making that decision, whether to go ahead and answer that question in a hearing, or when you're set for statements, depositions, what have you, you have to decide, okay, well, it might have consequences here, but I don't think it's going to harm me down the line, because they'd have to prove that going off this statement and what little else there is to make a criminal case against me. That is a good point, because with that in mind, it might help somebody make the decision, do I go ahead and answer this in the administrative or civil hearing, coming up this week?
And what I would strongly encourage, like either clients or family law attorneys, is if you have a situation where there might be a potential criminal consequence, go out and hire somebody who's skilled in criminal defense. And
we might know somebody that
right,
can help you with this.
right. And I have cases right now where I have a family law, case, and then I'm dealing with some federal criminal attorneys along with them, because that's not my area of expertise, right? And so I'm talking to them and saying, okay, what do you need me to do? And they're saying, this is what I want you to do. And I'm saying, well, this is what I need you to do. And we're teaming up for the benefit of the client. And it's unfortunate because it's very costly, right? I mean, running two attorneys at one point, most of the time, if in the context of a family case, if you have one party who is paying criminal defense attorneys because they found themselves in some sort of trouble, the judge is going to hit you on the divorce proceeding and say, hey, I'm not going to make your wife or your husband pay for that, so now we're taking that off the top when we're dividing the assets. But you have to do what you have to do in order to protect yourself, because otherwise it could get very ugly very, very quickly.
Well, yeah, that would be the optimum thing if you have the time before things really start breaking and falling apart,
Mm-hmm.
as well as the ability to fund that,
Mm-hmm.
then that would be the thing to do.
Right. So, is there anything else we need to talk about?
So another intersection is, I guess, more family than criminals enforcements, right? They're quasi-criminal, probably not something that you deal with, right? But a lot of people don't recognize it as being a criminal proceeding. But you mentioned beyond a reasonable doubt, and that's what brought it up, is on a motion for enforcement, when you're alleging a violation of an order, the standard there is beyond a reasonable doubt, because you're possible jail time is what you're facing, right? And they have the right, a court-appointed attorney. They call it quasi-criminal, whatever the hell that means. I don't know. But, criminal when we want it to be, civil whenever it's convenient, right? Type thing. But same thing, like when they're asked questions related to an enforcement, right? We're telling them, shut up, don't talk, right? Because possible jail time.
What about protective orders and violations of protective orders? We deal a lot with that a lot.
Yeah, I haven't had one.
Not our clients. Our clients behave themselves, but some people.
Yeah, I haven't had one of those in a long time, but I've had those in the past where, it becomes a criminal case. The district attorney's offices have turned that into a criminal case. I don't think they're doing that across the board like they used to, but you used to see in the past where they would turn that into a criminal case where you defied the order and this is a crime and now you're being prosecuted. So, yeah, it goes back to what we're talking about. Again, I use the phrase gut check call. Do I make a statement in that proceeding, or do I hold back and see if we can somehow let the other evidence speak? If there's a possibility to postpone it at all, anything like that to try to avoid making a statement if you can.
We've done that too about like postponing. So there have been several times where we have delayed a final trial in the context of the family law case until you guys could get through the criminal case of it, and we could get our dismissal, we can get our acquittal, and then now we can talk about it, right? And let me tell you, Judge, what really happened, you know, so that I can win my family case after you guys have stepped in and done your job. Right?
Yeah, I've seen that as well in civil cases that get stayed until the criminal case, because the underlying facts, are pretty much the same in both. Get the civil case stayed, stop the proceedings, put it on, freeze it, so to speak, until the criminal matters is taken care of.
Yeah, because
that would be the optimal thing to do too.
Because unlike in criminal, in civil, pleading the fifth can be used against you, right? Judge can take that as an admission, whereas in criminal they can't.
It does. Yeah, it happens all the time, and the one that comes to my mind the quickest is Securities and Exchange Commission cases where there are civil enforcement actions in federal court. They're alleging usually sale of unregistered securities, or and federally the securities definition is very broad, so it could just be a promissory note, and they turn it into an SEC investigation. Anyway, point is, you have the same kind of deal where, okay, you're taking the fifth. Okay, that's going to be used against you when the judge decides, do we get this order, do we get that order?
Right.
And specifically, is held against you, so to speak.
Oh, same thing with us, in that knife incident. And, the other attorney, he also does criminal defense. And so he went through and he was basically, laying out the elements of the criminal offense. And every single time, invoke my fifth. And I mean, the judge, they sat there and they let him ask all of those questions, and he had the right to. And so it was just kind of like, well. And then what annoys me, and a lot of attorneys do this.
Probably a lot of things.
A lot of things to me. But then he started going into other, potential
this is going to be
criminal...
public before you start talking crap.
Like other potential criminal, and not just this person, but it happens a lot.
This person is very annoying.
Other criminal consequences or questions that could have criminal consequences, because that was not related to this particular incident, because he knew that my client couldn't answer them. And so then what happens is that it makes my client look even worse than what he probably is, and it was all used against him.
Makes him look very guilty at the moment, correct?
Yeah, because the judge, and again, it's within the court's discretion, right? So just because you invoke your fifth, they can say, well, I believe that he probably did this, or maybe he probably didn't. It's within that, in the civil realm, within the court's discretion. But 9 times out of 10, I think these judges are like, Guilty. Yep, did it. They're invoking. And so, yeah, we're going to go ahead and grant this protective order. We're going to go ahead and order, attorney's fees and spousal maintenance and all that fun stuff. So, yeah. But,
So, obviously, we're talking about all this out of an abundance of caution because we don't know whether criminal cases are going to be filed and all that stuff. But I was just thinking through this. We've handled a lot of family violence cases and sex assaults and all that kind of stuff. I've never had a prosecutor come in and say, here's your client's testimony from a PO hearing, or here's your client's testimony from a family hearing. Have you ever seen them use something that they got from a civil proceeding against a criminal defendant? You have?
yes.
Occasionally, not very often, like you say. I usually don't, but sometimes.
I don't know
Yeah.
I don't know that I've ever seen that.
So I've had, and I think it was one of your cases where
maybe I haven't, I
the
don't remember.
prosecutor didn't get the testimony, but the prosecutor was sitting in the courtroom.
I do remember that.
Yes, yeah, and so that we were like, oh crap.
Yeah,
I remember you
I
calling
do
me, and I was
remember
like, okay, well, this is not going to go well. So I've had that happen, and I have also had it happen where I am, it's a husband and wife case, and the criminal defense attorney for the husband was sitting there throughout the entire divorce proceeding, I guess, just taking notes, and eventually the transcript was requested, and in that particular case, the family law attorney was essentially using that time to prep for the criminal case, and so
I take it back.
yeah,
I do
that
have a
was
case
happened.
recently where the family law attorney actually went to the DA's office
Yeah.
and gave them everything. I do, yes.
Yeah. And I mean, we've done that too whenever we're dealing, with the family law case and the criminal defense case. You did it when you requested the transcript and sent it to the DA's office to use in the defense of it. But we've also gone through and we've done discovery on the divorce side of it. And we start getting proof of, listen, here was wife's motive to lie, right? Here's all of her Facebook messages to her boyfriend, and they were going to, flee the country, and she was going to take everything from the husband, and they were going to, live happily ever after. Let me show you all of these Facebook messages, and maybe, DA, you should probably dismiss this case because it's not going to go well, right? So, sometimes, honestly, and especially in, that example you gave, sometimes having the family law case or the protective order case and the criminal case running concurrently is actually a blessing.
Didn't somebody say this like
and-
20 minutes ago
But
in this
no,
podcast?
remember this case that we had where our client had been
If you
charged
talk about
with,
the guy that stabbed the girl,
that's what I want to talk about.
we just talked about that.
No, this is a different. But I thought you.
And there was a protective order hearing, and I got the discovery, and we used it to get the
Oh, I
case
thought you
dismissed.
filed the protective order.
No, the DA filed it.
Okay.
We
damn it.
represented the guy that
Okay.
did the stabbing allegedly.
But we had alleged that the wife had actually stabbed him also at some point. Yes.
Oh,
yes.
or his girlfriend
Girlfriend. Yes.
on the toilet. Yes, I remember.
Sorry. We have lots of fun around here. So yeah, but sometimes I do think it is a blessing. And so long as you're working with somebody who does criminal defense, because otherwise it's a hot mess.
That's a novel thought.
Yeah, I thought so. I always have those thoughts. So, anyway, I guess that's it. Is there anything else we need to talk about?
Anything you can think of, John? You want to add to it, or
No, covered a lot of good stuff.
Absolutely. Thank you so much for
Thank you.
joining us. I'm so glad that you were here. And you all, thank you so much for watching us on the consultation. Any social media platforms that exist, we are likely on them. TikTok, Instagram, Facebook, YouTube. Please like and subscribe. As we always state during this podcast, please do not accept this as legal advice. If you find yourself in a potential criminal case or family law case, make sure that you find an attorney that you trust, that you feel comfortable with. Tell them your story in its entirety and follow their advice.